My name is Louis Levinson, and I thank the Temple of Prayer for having us, and Charles for inviting all the candidates. Fairburn, my children were born in Fairburn, just a few miles from here, where I lived for about 10 years, so I'm very familiar with this community. Before that, in 1978, I graduated from Emory Law School, been a resident of Fulton County ever since. I practiced law for 40 years, and I can say, and I'm supposed to say something funny, so I'm going to say what I think is something funny, that the only lawyer in the room who I think has practiced longer than me is the chairperson of my committee, which is Ms. Hornsby. I hope you won't take that as an offense, Ms. Hornsby. There are stark contrasts between Judge Kirk and I, and it's not a bad thing for there to be stark contrasts. I served for 30 years, from 1984 on through 2015 as a part-time magistrate and a part-time state court judge, and I enjoyed being on the bench. I enjoyed the day-to-day activity of managing cases, high-volume cases, and I want to do that again. I don't wish to simply be a court administrator, although that is part of the job. I want to train the 20 or 30 judges that will work under the chief magistrate. I want to be sure they are clear on what the law is. I expect there will be questions tonight of me and Judge Kirk that suggest that we should be mindful of many personal troubling things that go on in our community. I'll reserve the rest for.
Thank you. Chief Judge Kirk, your 2-minute opener.
Good evening. Thank you all for being here. I want to thank you all for spending your time with us today. In 2014, something happened that changed the Fulton County Magistrate Court. What happened was the people under the Gold Dome decided that the Fulton County Magistrate Court should look like the 158 other magistrate courts across the state of Georgia. As a result, they created, by legislation, an independent magistrate court. So as of 2014, there was a new magistrate court. That court was tasked with being independent, and that court was tasked with doing all the magistrate court duties that are set forth in the Magistrate Code. Good evening. My name is Cassandra Kirk. I am the Chief Magistrate Judge in Fulton County. I have been serving there for 3 years. During that period of time, I have increased the efficiencies of the court, the accessibility of the court, and I look forward to having you vote on May 22nd to keep Kirk as Chief Magistrate Judge.
Let's get into what the magistrate court actually does.
Give him a little love.
Let's get into what the chief magistrate judge or the magistrate court actually does. What is the brevity, what is the complexities involved in magistrate justice? And I will begin with Judge Kirk and then go to Judge Levinson.
So the Magistrate Court is a court of limited jurisdiction. It has both civil as well as criminal jurisdiction. On the criminal side, I like to say that the Magistrate Court is a triage court. And so what that means is we do search warrants, arrest warrants. Moving you from search and arrest, we move you to the jail. Once you get to the jail, the magistrates do first appearance, felonies as well as misdemeanor. The next step in that process is for a magistrate to handle all purpose, whether that is for a felony or for a misdemeanor. Why that is important is because that is your next opportunity for bond. That is also an opportunity for the court to hold the prosecution to its feet to the fire to make sure that cases have been accused appropriately and that they are moving along the path they need to. In the non-complex division, I heard Ms. Willis mention it, the magistrates will also take those cases to plea and arraignment and eventually to trial if that's in fact where they end up. That's on the criminal side. On the civil side, what magistrate court does is we do a high volume of civil cases, about 80,000 cases a year. The most known cases that we do are landlord-tenant cases, garnishment cases less than 15,000, as well as small claims cases less than 15,000. There are some other cases that we do, but that's the majority of what it is we do in magistrate.
Judge Levinson, in your view?
The advice I give to people who are asking for legal advice is stay out of court. But if you have to go to court, you want to go to the magistrate court because as a practical matter, that is the court that you're most likely in the general population to have interaction with. That's the court that not only has to be fair, but it has to appear to be fair. And the difference between the magistrate court, for example, and the superior court, and this is an important distinction that has to be realized by the people who elect a chief magistrate judge, is that we are not governed by the strict rules of the Civil Practice Act. That doesn't mean we don't follow the law, but it means that if you don't know what the rules of civil practice are, and 99% of non-lawyers don't know what that is, and I would say 50% of lawyers don't know what it is, unfortunately, and the result is it gives the magistrate court in a entry-level court, as Judge Kirk said, a wide latitude to fashion results that are more just. In fact, the Supreme Court of Georgia said when it established the magistrate court, or when the legislature established it, the Supreme Court set down the rules, was do substantial justice.
Thank you. The magistrate court is also called the people's court because you guys deal with so many people. And it is civil and, as you said, also criminal at times. Let's talk about bond setting. A lot of discussions I've had over the airwaves has been about bonds that are simply too high and the judge is well aware. In effect, giving that person a sentence before he or she is tried or convicted of anything. What is your judicial philosophy when it comes to setting a bond for someone in front of your courtroom? Judge Levinson, I will begin with you.
Well, the law sets down 2 or 3 criteria, and this is not the judge talking, this is the legislature talking about what you must consider in setting a bond. First, let me say, there are certain areas, certain criminal charges that magistrates cannot set bonds on. And magistrates have to understand the rules that prevent them from getting involved in certain bonds that only a superior court judge, like Judge Wolf or Judge Willis or Judge Farmer, would set on a case. So that's the first important distinction, which is that perhaps judicial activism does not belong in the magistrate court. But with regard to setting a bond for someone on an offense that a magistrate can set a bond on, the first question is this person, that would occur to me anyway, is this person likely to re-offend and be a threat to the community when he or she is waiting to go to trial, and will that person show up for trial? And the answer to that is, you look for whether that person has ties to the community, whether that person has a job, whether that person has the references from the community that suggest he or she is going to come back, because that's all a bond is an assurance that when the case is called in a higher court, that that person is going to appear to answer those charges.
Thank you.
As the magistrates sit both for state court and superior court, it's important for the magistrate judges to know and be aware of the criteria. And Mr. Levinson has indicated that there are 4 criteria, in fact, that the judges should use in order to set that criteria, in order to set a bond. The biggest concern is whether or not the individual is in jail because they cannot make a bond or because they have mental health issues. I am absolutely opposed to criminalizing poverty as well as criminalizing mental health. And so it's important for the magistrates to be able to assess those defendants as they are coming before them at first appearance and again at the all-purpose calendars to make a determination as to whether or not this person is dangerous, whether or not this person poses a threat to others in the community, will this person return to court, and make those determinations not based on the amount of money and not make that bond amount onerous.
For the most part, when you deal with somebody in front of you in magistrate court, they do not have a lawyer to represent them, for the most part, creating somewhat of an equalization with their issue. However, we know through actual studies that have been conducted that people of color have not received the same level of justice as individuals who are white. That has been well documented and well noted by scholars all over the country. What would you do, or what do you do, in your judicial ruling or rendering to stop that, to be a conscientious objector to those issues in your courtroom. And I will begin with Chief Judge Kirk on that one and go to Judge Levinson.
And so I was thrown when you first began describing it, because in the criminal case, anytime someone's liberty is at risk, they absolutely do have a attorney. And so moving to the civil context, which is what I believe you wish to speak about, it's important for us to simplify the magistrate court process. And one of the things that I have done while being chief is to actually win a grant from the National Center for State Courts. We were one of 4 courts that won that grant nationwide. And what that grant was to help us simplify our high-volume calendars. Our high-volume calendars, again, are landlord-tenant calendar, our garnishment calendar, as well as our small claims calendar. And what we have done is looked at putting videos online so people can actually watch what's happening, so they can figure out what they need to do. We've created pamphlets in easy-to-use 3rd grade language, which is what the papers are written in, which is what helps people move themselves forward. It's important for people to be able to empower themselves, and so we have created systems to make that happen or to help that move forward.
Thank you. Judge Levinson.
The term conscientious objector was not lost on me. That's a very difficult analysis for any judicial officer. The first thing that happens after one of us, Judge Kirk or I, win an election is we take an oath. And the oath that we take is to follow the law. Now, I'm not reluctant to say to the people who've appeared in the courts where I have sat over years that I don't agree with what I'm about to do. But here's the law in the book that says I have to do that. My job is to apply the law to the facts of the case. And we live in an era, unfortunately, where facts are elusive. At least our current president thinks the facts are elusive. And I believe that there's only one set of facts that govern all of us. And once you determine what those facts are, you apply the law to those facts. So I'd have to say, Mr. Ritchie, that it troubles me sometimes to follow the law. But that is unfortunately the oath that we take as judicial officers.
Let's talk about real estate, residential. As a magistrate judge, you guys will see a lot of cases dealing with landlord and tenant. Sometimes the tenant is simply unable to pay at that moment. As you suggested in an earlier answer, you guys are not bound by the exact same civil justice code. There's some flexibility there, and it is lawful flexibility. What is your judicial philosophy as it relates to a tenant-landlord dispute, and you understanding that the tenant simply needs time to adjust to the realization of eviction? And I will begin with Judge Levinson.
Well, first, this is the very court that I was involved in for 30 years as the sole judge for probably 28 of those 30 years, handling landlord-tenant cases in Fulton County. So I may not be smart, but I can lift heavy weights. You know, I've done the volume of those cases. The answer is that we must strike a balance between enforcing the law and the contract that people sign. Because in the absence of a legal duty, there's a contract, a lease contract that most people have signed. I have found that there are two categories of people who can't pay the rent. Those who say they can't pay the rent and those who truly can't pay the rent. Perhaps discernment developed over 30 years, and I think I can figure out those who can pay the rent are just not able to do it today. And what we established in Fulton County about 20 years ago was an ADR, Alternative Dispute Resolution System, a fancy term for mediators. We brought mediators into the court to help resolve those cases that were segregated from the volume of cases where the parties really wanted to work it out, but each side was too proud to say so. So I sent them to mediation, and 90% of those cases get settled.
All right. Judge Kirk?
And so the landlord-tenant cases, the beginning of those cases is with that first affidavit filed by the landlord. This is an opportunity for the court to assist the tenant, and we do have a housing assistance clinic which assists those tenants making determination. Do I have a case which I can, but for which I need a lawyer, meaning is there somebody from the Atlanta Volunteer Lawyers Foundation that I need to seek out? Or is this a case where I simply answer in order to get additional time? Because the sad fact is, the law is the law. And while the judge may be interested in giving extensions, if the parties have not agreed to those extensions, it's a problem. And so I don't practice paternalism. And so what happens when parties come before the court? At each setting, there is an opening for the dispossessory calendar. And that opening says, please work your cases out with the mediators. The mediators are here to help you. If in fact you wish to make this decision, the court encourages you. Everybody go to mediation. If in fact you come back, the court will make the decision based on the law, and the court will follow the law. So there are two opportunities for tenants to understand and evaluate their case. The first is with the Housing Assistance Center, which helps them file an appropriate answer. And the second is at mediation before they actually come before the judge.
Both of you have very qualified credentialing in the legal arena. Let me ask you, outside of the legal arena, what do you bring to the courtroom? And Madam Chief Judge Kirk, I will start with you.
And so for the past 25 years, I have served in this community. I have served the community. And so despite my legal credentials, I have also done service. And I think it's important for people that want to judge to have done service. It's important for you to see people on the other side of just seeing them in front of you on the bench. I have served as an elder at my church. I have served as I've served as an elder at my church. I'm a member of Alpha Kappa Alpha Sorority Incorporated. I am a member of Leadership Atlanta and do continuous alumni activity there, as well as with the Regional Leadership Institute. I think it's important for judges to broaden their legal aspects, as well as it is for them to broaden themselves in the community.
Judge Levinson?
I'd give two answers to that question, Mr. Ritchie. One is, over the last 15 or 20 years, I've been associated as legal counsel to a variety of Alzheimer's and dementia organizations. You'd be astonished at the volume of folks that are exploited financially and personally, unfortunately mostly by family, when they have lost their faculties. And so I'm advising organizations on a pro bono basis. I realize that's somewhat legal. The other thing that is service-oriented, which I take pretty seriously, for which I do free, is that the magistrate court judges, of which there are, as Judge Kirk said, 159 chief magistrates in this state, are trained every year and required to take a certain number of hours for recertification, and I'm one of the instructors that travels around the state to train the magistrate judges, some of whom you should know are not lawyers. Many of the counties, a vast number of the counties in Georgia do not require magistrates to be lawyers, and recertification is valuable in educating them to follow the law.
Thank you. Let's talk about usability of the magistrate court. What are your plans, and this is to Judge Levinson, what are your plans to increase the usability of the local magistrate?
Well, I think what you're asking me is access to the courts.
Yes.
Thank you. Is my voice that bad? Access to the courts is really what it means. You should be able to walk in the courthouse. If you can't read or write, you should be able to come in and file a grievance with the assistance of a clerk. You should be able to file a response to a complaint if one was filed against you, and you should get the assistance of a clerk who's not permitted to give legal advice, but is permitted to help you fill out papers. Unfortunately, the system currently, and this is a change that I would effectuate, the system currently has mandatory electronic filing. Now, I ask how many of you are completely familiar with how to file things electronically? I will not raise my hand if that question is asked of me, because I don't know how to do that kind of stuff. But the system currently mandates everyone who walks in the courthouse has to file something electronically. The old system doesn't work. I believe that denies people who are, and I've read hundreds of thousands of papers that people have filed, are literally illiterate, literally cannot read and write. And if you force them to use a computer system they don't understand, they're denied access. Secondly, they should have the ability to get, as Judge Kirk said, the assistance of the AVLF lawyers, Atlanta Volunteer Lawyers Foundation lawyers, or be referred to Atlanta Legal Aid if it appears from their answer that they need assistance.
All right, thank you. Chief Judge, I will allow you to answer that because you do currently oversee the current system.
And so what I will say in response in that 30-second rebuttal is that there are navigators. There is someone that is on property that can assist anyone that is unable to use the electronic filing system. So there are clerks that are designated, that are in TG 100, that are specifically designated to help. You sign up and someone walks you through what it is you need to do in order to electronically file the document. And the truth is, the number of pieces of paper that the magistrate courts touch, electronic filing is the only way to keep the magistrate court moving into the 21st century. Anything else turns back the hands of time. In terms of what it is that I am looking to do and moving forward, I'm looking at online ADR because everyone doesn't need to come down to the courthouse, pay $7 to park, wait 3 or 4 hours just to go to mediation. There are online mediation systems that are happening in other places in the country that I have seen when I was in Salt Lake, and so I believe that that is worth exploring. The other thing is that when you come to court, that's the only place you come when you know you're going to sit and wait. And so how can we make people's time more efficient, more effective? And I will tell you is that the same way they do it with the DMV system. There are numbers. They can tell you who's being served. You can figure out how long you're going to wait, how much time you have. That's one of the options. The other things I would like to do go to efficiency and accessibility to the court.
Okay, thank you. Let's go to the Q&A segment from the audience. Does any audience member have a question? Okay, in the back right here, Nicole.
Hey, this is.
Hold on, wait for the microphone. Okay.
I was wondering, a basic question, Mr. Levinson, why you and not her? And same for Judge Kirk, why you and not him?
Okay, Mr. Levinson, your answer first.
That's a great question. My wife asked me that the other night, and she's here, so she'll hear the answer. I served for a long time. Fulton County is my family. I worked as a lawyer and as a judge in Fulton County. And when I retired, sort of, in 2015 after Governor Deal appointed Judge Kirk, people came to me afterwards and asked for my assistance in correcting some things which Judge Kirk had put in place. It's just a philosophical difference about the way things are being handled. That doesn't mean it's wrong the way Judge Kirk is doing it. It just means I believe it could be done differently and better. And there was a history of 30 years or more of doing it a certain way that was more constructive amongst the courts. There was a family of relationships between the magistrate court, the state court, and the superior court. What has developed is a separation of those powers that has made it more expensive for the county to operate and more complicated for the courts to share what should have been joint responsibilities. So that's just one reason.
Okay.
Do I have a 30-second rebuttal?
You do.
And so change is scary, but it's inevitable. Because the truth is, when this court was created, it was created after a task force studied the processes and what was going on. And what the task force realized is that magistrate court was being left behind. That work that should have been done by the magistrate court on behalf of the magistrate court was not getting done, because magistrates were being parceled out to do the work of state court, to do the work of superior court. And so when I came, I believe in the dignity of the magistrate court and the dignity and qualifications of those magistrate judges that are sitting there. Thank you. And so in terms of why me and not Mr. Levinson, because there's time for change, and the progress that this court is making is absolutely necessary in order for Fulton County to become a quality magistrate court. And so the old way of doing things, what that resulted in was 30,000 small claims cases that had been open from 2010 to 2015. So I walked in and said, tell me what the backlog is. Everyone looked at me like they didn't know what I was saying. What I'm saying is, tell me where the old cases are. Where are the things that you have not taken care of? And so since I have been on this bench, that is what I have been doing, is taking care of the business of the magistrate court. In terms of it being more expensive, it's not true. The budget for the magistrate court part-time judges has been cut by almost half. The judges that were serving in state court continue to serve, but they serve at a reduced rate because that budget has been cut in half. In terms of working with the Superior Court and looking at really what the statute said, and that's what I believe, that's where the friction has come, because I believe everyone should be responsible for what the statute says you have been, or what you should be.
Okay, thank you. Any other questions from the audience? Madam?
Chief Judge Kirk, you've shared with us many of the changes that you've implemented in the magistrate court. Can you share with us what your professional background and experience was before you became chief magistrate? And then following that, I wanted to ask Judge Levinson, you served in the magistrate court for 30 years in a part-time capacity. What were you doing professionally in the rest of your time?
And so I began my career first as a labor and employment lawyer at a boutique firm. From there, I moved to an assistant district attorney in Newton County, moving from Newton County into Fulton County, moving later into being a child advocate attorney, also serving as Director of Legal Services for the Child Advocate's Office, Director of Legal Services for the Georgia Merit System, as well as now serving here. I have been a juvenile court judge, an associate juvenile court judge, which was also a full-time position. In that role, I spearheaded the Choices program, which was a juvenile drug court program, and so I was the first to do that program in juvenile court. And so I have a breadth of experience that makes me unique and qualified for this position.
Thank you. Judge Levinson?
The first question was, what was I doing in the magistrate court, or
What did you do professionally before?
Well,
Or during that time? Part-time?
Since 1978, when I graduated, I've been essentially a sole practitioner. I never worked for anybody else, maybe because nobody would hire me, but the result was I started my own law practice. And it was a varied law practice. Back in the old days, we walked to the courthouse and took appointments on criminal cases for people who couldn't afford an attorney and tried those cases. Got a civil practice going. I was appointed in 1980 as the Fulton County Administrator and Guardian for those incapacitated adults who didn't have family, who needed their estates administered, or were mentally incompetent and needed someone to look after their financial affairs. I would say, and this sounds like I'm tooting my own horn, but I guess I'm supposed to do that if I'm running for an office. I have fought City Hall several times, so to speak, once literally. 1996, there were about 235 Olympic vendors minority businesses, came to Atlanta to do business with the city of Atlanta that were ripped off. I sued the city of Atlanta for 9 years, finally settling after Bill Campbell left office and Mayor Shirley Franklin came in office and authorized the resolution of the case. That's just... Yes, sir.
Thank you. Any other questions?
I do have a question. My question is, I'm sitting up here, I'm a novice, and I keep hearing magistrate code, state code, magistrate code, state code, and like y'all co-mingling them codes. Can you explain the difference between state court, magistrate court? I ain't been to court. I might have to go to court. I need to know what the court is.
You need to be in court. Okay. All right, we'll start with Chief Judge Kirk on the separation of the courts.
So the magistrate court is a court of limited jurisdiction, and what we do is really triage criminal cases. In terms of civil cases, what we do is mainly handle civil cases less than $15,000. So there's a dollar limit. When you start talking about adjudications on misdemeanors, and when you start talking about heavy medical malpractice cases, those cases are happening in state court. The next level of court is going to be superior court, which is where all the felony cases are handled, where there are 3 magistrates sitting part-time in their non-complex division. And so that's the problem, is that the magistrates sit in each of those courts. And so when you say someone is a magistrate, they also have the ability to sit in state court. They have the ability to sit in magistrate court. And superior court. And one of the things that I have been most proud of is that our judges will rotate into those systems, because the truth is, at some point, 5 of the 10 magistrates, 5 of the 10 state court judges, 6 of the 20 superior court judges had been magistrates. So magistrate court is truly a training ground for those people that are moving to the next level court. In terms of, I think I've confused the issue more, but the truth is misdemeanors, state court, superior court has felonies, superior court and state court both have civil jurisdiction. It just depends on how fast you want to get there.
Judge Levinson?
Well, let's start with the differences in the courts. The state and superior courts are substantially the same as the higher level trial courts of civil matters. The only difference between the state and superior courts is that state courts handle misdemeanors, which is fines up to $1,000 and up to a year in jail. And felonies are stuff beyond that. So the state superior courts can give you jury trials on civil cases and can give you jury trials on criminal cases. But state court is misdemeanor only, and felony court is superior court only. Magistrate court will never give you a jury trial. Why? Because the magistrate court, as Judge Kirk said, doesn't have the jurisdiction to give it, which means if you elect me or Judge Kirk, we, or one of the magistrates that we select to hear the cases, will be the only judge that makes a decision on your case, whether it's a criminal warrant application. For example, if you have a dispute with one of your neighbors and you believe he or she's committed a crime, you come to the magistrate court to take a warrant application. You have a hearing in our court. If you believe that there's a civil claim you have for business or personal matters that is up to $15,000, you bring it to our court. You get a very quick jury trial. Now, no disrespect to the contestants for the superior court, but they tell you they give you curb service. That means 9 months. In the magistrate court, you'll get a hearing in 30 days.
All right, thank you. Any other questions from
Thank y'all.
the audience? Any other questions? Don't want to miss anybody? Looks like there's no additional question. Let's give these 2 candidates a round of applause. Thank you very much.